going to talk about agency law, which is derived from common law, but very important to understand other areas of law like employment law. So as you know, common law can be modified by statute or preempted by statute, and that's true with agency law. Again, we look at the life cycle of formation, determination of an agency relationship. It can be in writing, it can be oral, like a contract, that kind of thing. One type of agency relationship you might be familiar with is a durable power of attorney or healthcare directive. This is a great resource. You can Google it. They give you forms for free and everything else. So that's all cool. Now, an agency relationship, you have the principal and the agent. You could, in the employment world, say the employer and the employee. You could be a bona fide employee or independent contractor or a volunteer. So principal duties include compensation for the agent, reimbursement, indemnification of the agent if they get into some sort of trouble while acting within the course of their duties, cooperation, which is pretty self-evident, and then this one, safe working conditions, which is an important common law predicate for federal and state laws protecting workers on the federal level. Safety laws include OSHA, Occupational Safety Health Administration. On the state level, state of Washington, we have Labor and Industries. Duty of the agent, performance. Yeah, again, so long it's a legal arrangement, notification of the principal of anything that would be of note. Loyalty is key. You can't have a conflict of interest. Obedience to the principal, and then accounting for whatever monies, et cetera, that are involved. Agent can have various authority. Again, this can be oral or written. Express, specifically, you hire somebody to maybe sell your house, a realtor. They have express authority to represent you, you being the principal in the sale within limits. Implied, the assumption is you may have a job like a general manager. It's implied that you have authority to do whatever it takes. Apparent authority, this is a big one. How is the agent, how does the agent appear to third parties? Does it appear that the agent's working for the principal? And this is a big legal landmine there. Ratification is where the principal ratifies whatever the agent does. This is standard for new businesses, which are have agents out there trying to, drum up support, maybe promising stock or some sort of other benefits. Okay. Big issue that comes up with in agency laws, whether the worker is a independent contractor or employee. Worker could also be a volunteer. There are various tests used by various agencies under the common law, which the IRS uses. They talk about behavioral, how much control the principal exercises over the worker. The more control, the more likely the worker is going to be deemed an employee, which has a lot of ramifications. That includes liability for activities of the employee, torts, negligence, even intentional torts. But also, if the worker is deemed an employee, they are entitled to statutorily mandated benefits, minimum wage, overtime, unemployment comp, sick leave. They're protected from discrimination, etc. Whereby independent contractors are independent. They don't have that. They don't have that same type of entitlement, and they don't expose the principal normally to the liability. Okay, common law and agency tests. I mentioned financial. The more you pay a worker like an hourly person, the more likely they're going to be deemed an employee. That includes benefits, because independent contractors, independent type of relationship, the longer it goes on and the more critical it is to the principal's business, the more the worker is going to be deemed an employee. There's no fine, bright line. It's you look at the combination or of the circumstances. Yeah. So termination of the well, I should say you look at the totality of the circumstances. That's what I was thinking about. Termination, just like with common law, we talked about this. Lapse, the job is done, performed, etc. So it can be terminated by action of the parties, lapse of time, purpose achieved, mutual agreement, operation of law, death, insanity, impossibility, bankruptcy. That can all terminate that. So that is the world of agency law. All right.